Can you bluff your way towards settling your medical malpractice case or your accident case in New York? Would you like to know what this is all about? Come join me for a walk around the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. You brought, let's say, a medical malpractice case against your careless doctor claiming that you suffered significant harm and injury. And now, you had a medical expert at the very beginning because that's the only way you were able to go ahead and bring a lawsuit. However, during the course of the lawsuit, you had the case re-reviewed by the same expert who now backed out of the case saying, you know what, after reviewing all of these additional records, there is no possible way I could support your case, and I don't believe anything was done carelessly or wrong here. Now, you turn around and say, there's no possible way we can go to trial now. However, maybe we can bluff the defense into thinking that we are going to go to trial. And if they don't settle, then we will go to trial and let a jury decide. And more likely than not, you believe you'll get a verdict in your favor. Well, there are two problems with that particular thinking. The first problem is, number one, you can't go to trial without having a medical expert. You are required in New York to have a medical expert to support your claims to be able to testify at trial in front of a judge, in front of a jury in New York, that you have a valid basis for a case. Your expert has to be able to articulate what exactly was done wrong by the doctors or doctor that you have sued. Your expert has to be able to articulate how that wrongdoing was a cause of your injury. It doesn't have to be the cause. It only has to be a cause. There has to be that link, that bridge between the wrongdoing and your injuries. Lawyers call that proximate cause. And now your injuries have to be significant and permanent. You might have significant permanent injury. However, if you cannot establish with a medical expert that the doctor who treated you was careless, that he violated the basic standards of medical care, there's no possible way you could get a verdict in your favor. Likewise, if a jury did come back and say, you know what, the doctor was careless, however, his carelessness, his wrongdoing, did not cause or contribute to your injuries, then in that case, also, you would not be entitled to a verdict in your favor. Why? Because you would not have been able to establish that link, that proximate cause between the wrongdoing and your injury. All right, so putting aside the fact that you don't have an expert at this point, now what's the issue? The issue is that you believe that you can somehow bluff the defense into thinking that you do have an expert. And if they don't go ahead and start settlement discussions now and settle this case now, you are going to imply and threaten, in a sense, that you are going to go all the way through trial and now let a jury decide with the expectation that they will likely give you a verdict in your favor. Will that work? Will that fly? In my opinion, the answer is absolutely not. Now you might be thinking, why not? Why can't you bluff them into thinking that you have a medical expert and are ready to go to trial? I'll tell you why. In New York, as we get closer to trial, we are required to notify the opposition, the defense, that we have retained various medical experts to testify on our behalf. Not only do we have to tell the defense that we have retained one or more experts, we are required to give and exchange with the defense the credentials of our experts. Now, interestingly, in medical malpractice cases in New York, we don't actually identify by name the various experts that we have hired to come and testify on your behalf. Instead, to try and protect their identity so that they're not subject to harassment by the defense and their principals, now we are still required to provide the defense with our experts' credentials. Where did they go to medical school? When did they go to medical school? Where did they do their internship? Where did they do their residency training? And we have to provide dates. Now you might be thinking, wait a second, isn't that the same thing as providing or identifying your expert? In a sense it is, because once we provide those credentials to the defense, they plug that information into a database, and now it's going to churn out and pop out the name of our expert. Why does each side try and identify the names of our experts? We do that to try and dig up dirt on that particular expert. We want to see if that expert has ever testified before in court. We want to see and get the transcripts of any prior testimony this expert has given. We want to compare that testimony with the testimony that he or she is going to give in your particular case. In that instance, we can use prior testimony for this particular expert against them at trial when we cross-examine them. And that's one of the key reasons why those credentials are provided. So now let's get back to the question I raised earlier. Can you go ahead and bluff the defense into thinking that you have a medical expert and have no worries or qualms about going forward to trial? If you are now approaching trial and you have failed to provide an expert's information, an expert exchange to the defense will know that there's a problem. The defense will wonder why you have not shared with them your expert's information. The defense will wonder why. What's going on here? What's the problem? Did you forget that you have to do this? No. Any trial attorney knows that there is no forgetting the fact that you have to exchange your expert witness information if you expect to call a particular expert at trial. There's no forgetting that. You have to do that in a medical malpractice case in New York. So the defense is going to reach the conclusion that in all likelihood you don't have an expert at this point. Now, there are deadlines, there are timelines in which you are required to go ahead and notify the defense as to whether you have obtained or retained a medical expert to come in and testify. And if you now exceed that time frame, you run the risk that your expert is going to be prevented from testifying at trial. It's known as making a motion to preclude the expert. And in all likelihood, that request will not come until the time of trial when you're in the middle of your case and now you stand up in court and the judge asks, okay, Mr. Oginski, call your next witness. Your Honor, plaintiff calls the expert to the stand. And now the defense attorney jumps up out of his seat as if an ejection button was pressed and said, hold on, Judge. Oginski and his client failed to tell us that they were bringing in this expert within the appropriate time frame. So therefore, we are at a distinct disadvantage because we had no opportunity to go ahead and do a background search to try and dig up information on this particular expert. The judge will then turn to me and say, Mr. Oginski, is that true? Well, yes, Judge, but, and now if I try and give the judge some sort of explanation, reasonable explanation about why that occurred, the judge will, in most cases, not be sympathetic with our plight, regardless of the excuse. Which means there is a very good chance that the judge turns around and says, listen, Oginski, you did not comply with the court rules. You did not comply with the requirements to notify the defense in a timely manner as to who you were planning on bringing in as an expert. And because of that, they are now prejudiced and can no longer properly defend this case. Therefore, I am now preventing your expert, your medical expert, from testifying. Now, you might think, okay, what's the big deal? If the expert doesn't testify, you can call somebody else. No. If we have not notified the defense that we have an expert within the appropriate time frame before trial, and now the judge is preventing our only expert from testifying, guess what? Now we are screwed. Now we have no expert to support our case. And what did I mention earlier? That we are required to have a medical expert testify in order to support our particular case. So if we are unable to bring in a medical expert, now for legal reasons where the judge won't allow me to because we did not comply with the court rules, guess what? Now we cannot actually prove your case. We cannot show that we are slightly more likely right than wrong than what we are claiming is true. And therefore, the defense would be well within his right to ask the judge to dismiss our case before ever even getting to the jury because we are actually unable to prove it because we don't have an expert. So why do I share this quick information with you? I share it with you just to help you open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.